What's going on, beautiful people? It is your main man, the werewolf himself, Mr. Bad, blowing down the little piggy's house downs. All right, so all jokes aside, I want to thank you guys for supporting me over the years and helping me to get this channel to 62,000 subscribers. We are right around the corner from hitting 70,000. So thank you. Um, I'm just glad that you guys find this information useful or interesting, or you just like to entertain the wolf. Whatever it is, I appreciate it. Thank you for the donations. Thank you for the people in the paid monthly subscription services. Thank you, because every little bit helps. Matter of fact, I wouldn't be able to survive without you guys, in all honesty. Like, I've literally dedicated now my entire life to serving and helping you guys in this way, shape, form, and fashion. So thank you. Uh, I'll be honest, I'm not a rich man. It'll be a long time before I could be that, probably retirement age. But you guys are helping me to live a life where it is far more comfortable than it's ever been for me in my entire life. Definitely, I've always had a hard life with being harassed and picked on and whatever else and bothered by the law or bullies and trolls, especially when I was younger, just keeping it honest. So it's nice that I'm here. And with that being said, if you guys do see somebody out there using my information or talking jazzy, defamation of character or whatever else, which are suable offenses, make sure you report their videos and their channel for those things. Thank you in advance. As for those people, hey, all I can say is, well, you guys are helping my numbers to go up because the more videos you guys make, the more attention you're attracting my way. Even if you're trying to say I'm a negative person, and I'm really not. So that's why you'll never see me clap back at somebody. So I'm not going to be on your little shows. I'm not going to throw monkey fecal matter back and forth and do that. That's not how I get down. With that being said, it's all about the people and helping out the low income, the poor, or anybody who's just wants to have knowledge and live a little bit better of a life. That's what I'm here for, and that's what I'm going to focus in on. So we're not going to let anybody take our eyes off the prize. All right. So with that being said, this particular video, I did a clip on it a couple of years ago, and it's called "A Treatise on False Arrest." All right. So we are going to let me queue up my stuff here. We're going to go through that. I'm going to have the lovely assistant read, and I'm going to provide commentary. I'm also going to do a video where it's going to be the whole thing just being read, and I'm not going to provide commentary in there. It's just going to be the whole information. Some people like longer videos. Some people like things broken up into pieces. So this particular video will be broken up into some segments and in chunks. And then I'm going to try to, if I can remember, to have a link to the next video at the end of this one as it pops up as an option. So you can just go right to the next video and go through the whole manual, or you'll be able to go on Black Site 32 and get the whole manual for free and read it yourself. So there's also that. Um, with that being said, I think that's about it. Remember, guys, check out blacksite32.com. There are discounts. There are programs available for those people who need help with food and paying bills. I made videos on how to search out programs to help you do that. So look for those videos. As always, try to go through the videos before messaging me. Keep in mind that I no longer um, am in a position where I'm going to be answering all the emails that people come. So don't take it personal if I don't answer them. I've done it for years, and I'm just at a point in time now where other things, including reading and learning more informational things to bring to you guys in the books, is more important than answering every single email, especially for free. It takes up hours of my day. I'm still getting anywhere between 50 to 150 emails, so it has reduced. So thank you. I just don't have the time, so I apologize in advance. All right. So if I do see it and I do choose to answer, I may answer, but don't be mad or whatever. You're just gonna have to either book a consultation or hit up Black Site 32 for the questions option with the low with a minor fee for answering a couple of questions, or search through my videos and go there first. Okay, if you want the free way. So without further ado, let's get going. Oh, I appreciate you guys once again. All right, so let's check it out. Shazam! All right, so this is called A Treatise on Arrest and False Imprisonment by Charles A. Wiseman. So credit goes out to Charles. Charles, thank you in advance. Um, this information was put together some time ago, back in 93, so this should be considered um, fair use. And this was printed in the United States of America, where things are great and awesome and free and wonderful. So there's also no disclaimers that this cannot be used in the way that it's going to be mentioned here. Obviously, I'm not charging for this file or anything like that, so we should be good to go. All right, with that being said, let's have the lovely assistant start. And I'm going to do commentary. But this, guys, is definitely a video that you guys are going to want to share and get and learn. All right, so let's get going.
Length of time required.
All right, there we go.
5.
You guys should be able to hear the audio now.
Damages and liability. 6. Malicious prosecution. 7. 3. Arrest without /warrant. 9. The law of the land. 9. Summons. 10. Complaint. 11. Memorandum of law on arrest without warrant. 13. 4. Breach of the peace and felony arrests. 26. What is a breach of the peace? 26. Arrests for breach of the peace. 27. Threatened breach of the peace. 29. Conditions of felony arrests. 31. 5. Defenses to unlawful arrests. 32. Burden of proof. 32. Good faith and probable cause. 34. Ignorance of law. 36. Guilt of party arrested. 37. Immunity. 38. 6. The use of a warrant in arrests. 39. Warrant to be in the possession of the arresting officer. 39. Warrant to be shown upon arrest. 43. Invalid and unlawful warrants. 46. 7. Bringing arrested person before a magistrate. 49. Duty of officer. 49. As a trespasser ab initio. 52. Detainmentee is not a decision of arresting officer. 53. Arresting and releasing without bringing before a magistrate. 56. Defenses. 57. Distortions of fundamental law. 59. Due process neglected. 59. Fourth Amendment argument. 60. Highway traffic laws. 61. Resisting arrest. 64. Handcuffing. 69. Post-arrest booking procedures, fingerprinting, etc. 70. Limitations upon arrests. 72. 9. Conclusions and appendix. 74, 75. 2. 1. Introduction. This book is about liberty. It is about the lawful and unlawful means by which government acts in depriving an individual of his liberty. His right teaches that deprivation of liberty is more often arbitrary and unlawful than it is otherwise. At least this is always the tendency of those who hold executive power. Daniel Webster once stated this problem in these words. The contest for ages has been to rescue liberty from grasp awful executive power. Liberty is taken away or deprived most commonly by arrest and imprisonment. The practice of easy arrests and secret imprisonments has always been an earmark of a despotic executive power. To compound this problem, we have the legislative mills which turn out thousands of new laws every year. The passion of modern legislatures to regulate every facet of the most intimate concerns of everyday life is notorious. This would be oppressive enough if administered under the requirements of a warrant or summons. But it becomes doubly intolerable if every zealous officer is authorized to arrest on sight every person whom he detects breaking one of these laws. No one can be safe to leave their home or travel about for fear of being subject to thousands of unknown laws in which he could be instantly arrested for transgressing. One law review writer states the problem as follows. People no longer live their whole lives in the village in which they were born. They pass freely from place to place, and in transit go through innumerable towns and villages. The risk of being arrested on sight, because one's conduct contravenes some regulation which the wisdom of the local solons deems necessary, is appalling to any thinking person. It would be impossible to know at what moment one might become amenable to arrest. A revolution in England and the revolution of the American colonies are said by high authorities to have been largely influenced by promiscuous seizures and searches of persons and property. The history of our ancestors over the centuries teaches that a people cannot be free where the executive power can arbitrarily arrest or imprison citizens, or ransack at will the properties of the people. The executive power is limited and guided by the jaw of the land, or due process of law. If it was a restriction upon the King of England, it must be so for every petty officer today. In many of the treatises on the law pertaining to the rights of citizens, and in many of the older and Ben-Air Count cases, we find the declaration, the law is very jealous of che liberty ath citizen. What law is it that so regards liberty? It is the common law, and it declares that one who interferes with another's liberty does so at his peril. This law also prescribes how arrests are to be made, and the restrictions involved. Unianity of Pennsylvania Law Review, Volume 75, page 491, April, 1927. 2 night 1 foot. Baker, 117 Oregon 492, 244 Pac. 543, 544, 1926. 3. 2. Definition of false imprisonment. What constitutes false imprisonment? False imprisonment consists of any type of unlawful restraint or interference with the personal liberty of an individual. It basically involves any unlawful violation of the liberty of another. The ancient English legal scholar, Henry de Bracton, 1200 to 1268, tells us that false imprisonment is one of the oldest violation of rights known. Forcefully to deprive a man of freedom to go wheresoever he may is clearly a trespass. False imprisonment was indeed one of the 5 RST trespasses recognized by the common law. 1. False imprisonment is classified as a tort under the common law, and also as a crime. 2. It has been labeled as a tort, a trespass, an assault, a wrong, a damage, and an injury, giving one cause to bring suit against another for a remedy. Depriving a person of their liberty is legally no different than depriving a person of their property. A theft of liberty is a wrong by which remedy can be had, just as is the case with the theft of property. False imprisonment is a great offense due to the high regard the law has for liberty. In Chitty's practice of the law it states, the infraction of personal liberty has ever been regarded as one of the greatest injuries. The injuries to liberty are principally termed false imprisonment, or malicious prosecutions. 3. Unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. Actual seizure or the lay ing on of hands is not necessary to constitute an unlawful detention. For thus the only essential elements of the action are 1. Detention or restraint against one's will, and 2. The unlawfulness of such detention or restraint. 5. In his treatise on the law o/torts, Judge Cooley states, false imprisonment is a wrong akin to the wrongs of assault and battery, and consists in imposing, by force or threats, an unlawful restraint upon a man's freedom of locomotion. 6. Blackstone. In his commentaries on the law, 3bi. Com 127, states on this matter, every confinement of the person is an imprisonment, whether it be in a common prison, or in a private house, or in the slokes, or even by forcibly detaining one in the public streets. Point 7.
Now, why can they say that? They can say that because we have constitutional law. Everything that they do to us is under a contract, implied contract, verbal contract, but no physical contract. Those things apply to you when you're operating as a public person with the strawman name and you do not rebut their actions. You use their stuff, you consider their property and in their game on the state level, and they can do these things. But if they overstep your rights and you know that they're overstepping your rights, then you can sue them in federal court. The judge, prosecutor, clerk, police officer, sheriff, none of them are above the law. But when you're operating as one of them, you can't do almost anything to them because you're underneath them. You have to overstand them in the private. Take them to federal court. Use federal court, Supreme Court opinions, court cases, your constitutional rights. Look up deprivation of rights and color of law, 241, 242. All right, let's go.
7. SMDS Foundalion 0/4. Thus any type of detainment or confinement of a person, or restriction or deprivation of their liberty or freedom of locomotion, where he is compelled to remain where he does not wish to remain, or to go where he does not wish to go, is an imprisonment. The only question thereafter is whether or not the imprisonment is false. The word false comes from the common law and is synonymous with unlawful. A false arrest is one means of committing a false imprisonment. In describing false imprisonment as being the unlawful restraint of the liberty of the citizen, or of the primary right of freedom of locomotion, the Supreme Court of Idaho also stated, "Imprisonment is any restraint of the personal liberty of another, and prevention of his movements from place to place, or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority." 8. In reviewing several EXT book definitions on false imprisonment, the Supreme Court of North Carolina stated, "False imprisonment is the unlawful and total restraint of the liberty of the person. The imprisonment is false in the sense of being unlawful. The right violated by this tort is freedom of locomotion.
The right
It
of
belongs
freedom of
historically to
locomotion
the
is a
class of
right.
rights known as simple or primary rights. The theory of law is that one interferes with the freedom of locomotion of another at his own peril. Point 9. A rather complete description of what does and does not constitute false imprisonment was given by TB Supreme Court of Kansas as follows.
They are telling you you have the right protected by the Constitution of locomotion. This means to go from one place to another in your own personal horse, wagon, vehicle, whatever. But when you accept the terms motor vehicle, motor carrier, U.S. citizen, driver, you're using their words. Now you cannot just adopt the new words, get in your vehicle and say, "Oh yeah, I'm out, cool," or just put on your plates because their computer, their God, shows that you're still a U.S. citizen and your vehicle's owned by a U.S. citizen and it's registered in their system as being a member of theirs, and you're using that membership inappropriately. You have to watch the videos on Right to Travel if you're going to do that. But in general, they're just telling you here, if they're arresting you, whether you're in your car or not, or whatever else, depending on what you've done, and they don't have the right things in place, these are violations. I don't care if they give you a ticket. I don't care if the police officer thinks he's right. If he doesn't follow all the steps, he's wrong. If he misses a step, he's wrong. If it denies you of your rights, your civil rights, and your constitutional rights, he's wrong. But you have to get through the moment so that you can go after them financially later. You are not to act or operate as a belligerent or a combatant. No false claims. You keep straight to the facts and you will be successful. You do not resist unless they're doing something way inappropriate, which unfortunately has and does happen out there at times, whether sexual in nature or robbery, then you do have the right to resist if they're going to violate you on that level. But in general, they should be following the law. And if you need to, you call their commanding officer or 911 so that other officers can be on the scene. You should never be on the scene ever with one officer by himself. Request a commanding officer. Now, if you're doing something illegal or stupid, well, then you deserve the normal and within legal scope of punishment and arrest, period. And for the record, the do not detain passport does not make you above the law. Nobody's above the law. So do not do stupid things with it. It only means if you're not doing anything stupid and you use that, under normal circumstances, you are not to be bothered or detained. But if you mix jurisdiction by having your regular car and it's not out of their system and having a passport, you are confusing things. Now, constitutionally, they would say, well, you're enjoying the privilege, so you're in their system. Once again, my dog poop cake theory. If you take some dog poop and put it in a cake and make the cake, the whole cake is tainted, right? Right. So if you're trying to be a national and then you got your driver's license or whatever else, and then you're trying to use your passport to save your butt, well, I don't want to have a ticket. Well, you've mixed those things and the whole thing is tainted. So because your name is still on the registration as a US citizen, they're going to ticket that. Now, do most cops let you go? Yes. It's because they don't want the headache and the extra paperwork. But that doesn't mean that you're above the law or you just, this gets me out of stuff. It just means they have the right at any point in time to ticket or not ticket, and they're choosing not to because some of them understand and respect what you're trying to do, but you have not done it right. You have not perfected it unless you watch all the videos and you have everything removed from their system, and then you're operating privately. And if they do overstep while you're traveling privately, then either you didn't do something right, or they are overstepping the law because they don't know any better. Because if they know what they should know, they would know that they're setting themselves up to be sued on the private side and the public side, and they wouldn't do it because officers have lost their homes, their marriages, their kids' bank accounts because they don't have their stuff protected like they think they do, not from somebody who knows how to sue them the proper ways. Okay. Remember, guys, though I do not do court cases, for those people who keep asking, yes, I will help you analyze the basic understanding of what's going on to help you set a defense, but there is a different fee on Black Site 32. It's not the normal consult fee because we're not doing a normal consult. So you're not going to pay the normal low fee for a regular consult. There is a court consult fee, and it's just education. I'll put you in the right direction, teach you where they messed up, and then you have to do the actions. I do not take any responsibility for success or failure. That is on you and the courts, but I will tell you how to then go from that failure if you get it on the first round and how to be successful most likely on the second round. But once again, no guarantees. Okay, which you're not going to get a guarantee from a lawyer. Ask them to put anything in writing after paying that $2,500 deposit as a minimum. But I digress. Let's get back to it.
Follows. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual. The wrong may be committed by words alone or by acts alone, or by both, and by merely operating on the will of the individual, or by personal violence, or by both. It is not necessary that the individual be confined within a prison or within walls, or that he be assaulted or even touched. It is not necessary that there should be any injury done to the individual's person or to his character or reputation.
I mean, are you guys understanding this? They're saying that an officer doesn't even have the right to touch you. Ever. Even as a U.S. citizen, unless you're committing a crime. Okay? Detaining you, stopping you, and asking you, hey, are you arresting me? No. Am I detained? Well, yeah. Then you're stopping me, which constitutes an arrest. Because I'm not able to go and do, well, I'm just trying to see what's going on. Well, okay, that's not an order. I'm not military. I don't work for you. You don't own me. I pay your salary. Oh, they really don't like it when you say that part. So not advised. No reason to make enemies. But they don't have the right to do those things unless you're in the act of committing a crime, or you've committed a crime, or you fit the description of a crime or a criminal. And then they have to prove those things. Okay, but let's go on.
Reputation. Nor is it necessary that the wrongful act be committed with malice or ill will, or even with the slightest wrongful intention, nor is it necessary that the act be under color of any legal or judicial proceeding. All tie is necessary is that the individual be restrained of his liberty without any sufficient legal cause therefore, and by words or acts which he fears to disregard. Lo. False imprisonment exists not only by words or acts that one fears to disregard, but also by such acts and measures that he cannot disregard. No fear of disobedience need to exist. If someone causes a situation that makes it impossible for another to exercise their liberty or locomotion, it is a false imprisonment. False imprisonment is the name of the category for those torts that unlawfully deprive or interfere with the liberty of a person. Under this category, the unlawful arrest is the most common type of wrong committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room, jail, or other location. Definitions of false imprisonment usually come from unlawful restraints of this nature. 8 Griffin versus Clark, 55 Idaho 364.
So the section down here that she's reading, these are Supreme Court cases that are called opinions, where they've already proven the information contained in the book or the read here. So this is law. This is constitutional law. Some of these are, other court cases or whatever else. But in general, these are law. They've already been proven in the Supreme Court, District Court. This is real law. This is lawful. So there's no arguing this. This is real. But there's more to court than just that. But you'll understand that in court, on the lower level, they don't have to go by this because this should not be used in their jurisdiction. This is why a lot of people fail. They'll say, well, this court case, and they go, yeah, we're going to ignore that because this is from a different jurisdiction. You would have to use this information by taking them to federal court. Okay. Turn you guys out a couple of bones here, some gem drops. All right, we're going to talk more about this. And for those people who wanted to get into the seminars, Black Site 32, I've got a page called Seminars where I will be talking about the stuff that I've been through. It's education only. We will have some mock trial type questions and things. Right now, it's only open to the VIP, but soon it'll be open to everybody who wants to get in there. This is for private people only. Which essentially is open to pretty much everybody, as long as you're in private capacity. And we will go over some stuff, but we're going to talk about health. We're going to talk about everything, really everything that we can use on a daily basis, a little bit of trust, a little bit of this, a little bit of that. It'll all be on there. So keep checking back on that. Right now, we're going to keep going.
364. False imprisonment has been well defined to be a trespass committed by one man against the pen on of another, by unlawfully arresting him and detaining him without any legal authority. L1. The law sets such a high value upon the liberty of the citizen that even an attempt to unlawfully arrest is esteemed a great provocation. 2. All the authorities agree that an arrest may be made either with or without any physical force or actual touching by the officer. 13. Thus any illegal restraint of one's personal liberty by the act of another gives that person a cause of action for false imprisonment against the one causing the illegal restraint. Prima facie any restraint by fear or force is unlawful. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual usually made by an arrest, and physical custody or restraint is not essential to the effectuation of an arrest. So if an officer tells a person that he is under arrest, and he thereupon submits himself the officer, going with him and obeying his orders, such person is deprived of his liberty, and if the act of the officer is unlawful, it is false imprisonment. In all cases in which there is no physical touching or seizure, nor any resistance, the intentions of the parties to the transaction are to be considered. In such a case, there must have been intent on the part of one of them to arrest or restrain the other, and intent on the part of such other to submit. 11. Rigged versus High-Grade Seed Company, 45. Under the belief and impression that submission was necessary. 14. The following definitions will provide further insight into the nature and elements of false imprisonment. False imprisonment is the unlawful restraint by one person of the physical liberty of another, and as here used the word false seems to be synonymous with unlawful. 1. Any exercise of force, or expressed or implied threat of force, by which in fact the other person is deprived of his liberty, compelled to remain where HC does not wish to remain, or go where he does not wish to go, is an imprisonment. False imprisonment is the unlawful arrest or detention of a person, without warrant, or by an illegal warrant, or a warrant illegally excluded. 17. Any restraint, however slight, upon a nuller's liberty to come and go as he pleases, constitutes an arrest. 18. Length of time requirement. The tort or wrong of false imprisonment occurs
Tort is a legal remedy, which we did videos on that, on how to be compensated for their actions, or the wrong imprisonment or false imprisonment or illegal imprisonment, unlawful arrest. Okay?
instance that one is restrained in the exercise of their liberty. There is no unreasonable length of time for a restraint before the laurel can be claimed.
Tort.
False imprisonment at common law and elsewhere consists in the unlawful detention of the person of another for any. 14. Johnson v. 6. Time, whereby he is deprived of his personal liberty. 19.
So what they're saying is whether it's 1 second, 1 day, 1 month, or whatever it is, if it's not done properly, it's unlawful. They can be sued for that.
Where two people are traveling in a car and stopped by police, and the party not driving is put in the police car and told to wait, the officer doing so is guilty of false imprisonment.
Did you hear that? Even if the officer says, oh yeah, hey, I just need you to hang out over here and not go anywhere. Just hang out for a second. That's an arrest. Oh yeah, just here, sit in the police car while I talk to your buddy. That's a false arrest. Officer, am I free to go? No, you're being detained right now. Okay, well, that's an arrest. Well, I'm not arresting you. I don't have handcuffs on you. That's still a arrest. And it's false imprisonment. Your locomotion, your ability to use your vehicle, walk, your feet, your horse, your goat, whatever the hell you're riding on, skateboard, that's an arrest.
Imprisonment. Even though the person was in the police car for less than a minute, it was an arrest, as the officer had no authority for confining him in the car. Even where police officers stop a moving vehicle for a brief detention, it is sufficient to constitute an arrest. 20 where one is told to stay in their car by an officer, though it be for only 10 seconds, it is an arrest. Time. Duration is not a factor in making an arrest.
Nope.
False imprisonment is defined as an act which, directly or indirectly, is a legal cause of confinement of another within boundaries fixed by the actor for any time, no matter how short in duration. Makes the actor liable, 0 the other. 21. When one is approached by an officer and questioned about his identity and actions, this is only an accosting, not an arrest. 22. Damages and liability. One who interferes with another's liberty of locomotion does so at his own peril. All who do so without lawful authority can be sued for the trespass upon liberty and loss of time. It thus is a very serious thing to deprive a person of their liberty. Since false imprisonment is a wrong suffered by a person, that person is entitled to receive a remedy for damages. Not only is a person entitled to receive a remedy for the deprivation of his liberty, but also for any other damages that are a reissue of that deprivation. False imprisonment was an indictable offense at common law and relief by the party aggrieved was obtained by an action for trespass 6 et armis, with force and arms. 23. The illegal arrest of a person without a warrant, or under an invalid warrant, entitles him to compensation for the damages sustained by reason of the false or unlawful imprisonment. The general rule of damages in cases of false imprisonment is that the person causing a wrongful imprisonment is liable for all the natural and probable consequences thereof. The plaintiff is entitled to recover damages for what the party wrongfully did in Murphiv. Countess, 1 Har. Delaware, 143, in an action for trespass, assault and battery, and false imprisonment, the court held that the plaintiff could recover, not merely for the time to be constable was bringing him to jail, but for the whole period of his imprisonment. And in Mandeville v. Guernsey, 51 Barb, New York, 99, the court said, the arrest being wrongful, the defendant is liable for all the injurious consequences to the plaintiff which result directly from the wrongful act. 24. Unlawful interference with or injuries to the liberty of a citizen is a violation of his natural, inherent and absolute rights, which damage results as a legal consequence. 25. 19. 25 Minth. A false imprisonment generally includes an assault and battery, and always, at least, a technical assault. Assault. 26 An unlawful arrest, imprisonment and prosecution of a person can cause to a person many damages, including bodily pain, great physical inconvenience and discomfort, loss of time, mental suffering, injury to reputation, distress or anguish, humiliation of mind, shame, public ridicule, invidious publicity, and public disgrace. Some of these damages overlap to some degree, but all can and have been claimed in false imprisonment suits. Upon the subject of damages, the law specifies FWO kinds of damages or divides them into two classes. There are what are called actual damages, then there are what are called punitive damages. Actual damages are such compensation for the injury as would follow from the nature and character of the act. They are the damages for wrongs received and injuries done when none were intended. In a false imprisonment, they could include the pain and suffering which the average citizen would be supposed to suffer under such circumstances. They further can include the physical discomfort and sense of shame, wrong and outrage. These are also called compensatory damages as they compensate the injured party for the actual injuries sustained, and no more. Punitive damages are those that grow out of the wantonness or atrocity, or aggravated by the act. They are the injuries and sufferings that were intended, or occurred through. 7. Malice, carelessness or negligence amounting to a wrong so reckless and wanton as to be without excuse. 27. These are also called exemplary damages. Anyone who assists or participates in an unlawful arrest or imprisonment is equally liable for the damage caused. Thus, where a man was illegally arrested by a police officer, and was placed in a patrol wagon in which he was taken to the central station, it was held that the two officers in charge of the patrol wagon were liable, along with the arresting officer, for false imprisonment. 28. Malicious prosecution. In many cases of imprisonment or wrongful arrests, there has often been a misunderstanding made between the charges of false imprisonment and that of malicious prosecution. While both may often involve a restraint of one's liberty, the two charges are not interchangeable or synonymous. There is a fundamental difference between these two charges. They are made up of different elements, enforced by different forms of action, are governed by different rules of pleading, evidence, and damages, and are subject to different defenses. 29. One description of malicious prosecution is as follows. Malicious prosecution is an action ex delicto for the recovery of damages which have proximately resulted to person, property, or reputation from a previous unsuccessful civil or criminal proceeding, which was prosecuted without probable cause and 26. Black 1 foot. Clark's Crunsborough Incorporated, 263 NC 226, 139 S.E.2 D 199201, 1964. 8. With malice. Malice. In an action of this type, the burden rests upon the plaintiff, THONC, bringing the suit, to establish each and all of the following propositions before being entitled to recover, to wit, 1. He was prosecuted in a criminal proceeding or civil suit. 2. Defendant instigated such prosecution. 3. The prosecution terminated favorable to the accused. 4. Defendant acted without probable cause. 5. Defendant acted with malice. And 6. Damages that were caused. 30. In Indiana, a case arose where a man sued several officers for unlawfully arresting and imprisoning him in the county jail, and without any charge preferred against him. The defendants insisted his complaint was bad as it did not allege that the imprisonment was malicious and without probable cause. The state Supreme Court rejected this claim. There is a marked distinction between and Molly cios pros ciutian and false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is malicious prosecution. If it has been extrajudicial, with out legal process, it is false imprisonment. LL. An arrest or imprisonment can be malicious or false, but not both.
Okay, so the reason why that particular scenario was not handled correctly, because there's a difference. Okay, so an arrest or imprisonment can be malicious or false, but it cannot be both. You have to decide which one it is. If you try to say it's one or the other, and it's not that, they will drop it. Okay, but this is also in the Supreme Court. You don't have to go all the way up there. But in this case, they're like, okay, this looks unique. They only take about 70 or 80 cases a year anyway. So this would have been really settled on the federal level. So you cannot claim that they're both. You have to attack one of the other. Did they do it maliciously, or was it just false? In most cases, it's going to be false. Okay.
In a case of malicious prosecution, the arrest or detention is procured from malicious motives and withom probable cause, but was done under lawful process, whereas in false imprisonment detention is without proper legal authority. 32. One may be legally arrested for some alleged reason, but done maliciously. If is found to be not guilty, he then has a case for malicious prosecution but not false imprisonment. If the arrest is not pursuant to legal forms of the law, then whether he is guilty or not, he has a case for false imprisonment but not malicious prosecution. If this is done with malice, it would add punitive damages to best suit. In describing the distinction between these two charges, the Supreme Court of Oregon stated that foundation of the cause of action for false imprisonment is the right which even a guilty man has to be protected against any unlawful restraint of his personal liberty, while a malicious prosecution case is founded upon the right of an innocent man to be compensated in damages for any injury he may sustain when a groundless charge is brought against him, even though such charge may be presented and prosecuted in accordance with the strictest forms of law. 33. In other words, the want of authority is an essential element in an action for false imprisonment, whereas malice and want of probable cause are the essentials in an action for malicious prosecution. 34. Somewhat different to the wrong of malicious prosecution is the charge of abuse of process, which is the misuse of legal process for an ulterior purpose, in which malice or ill will may also be a factor. Factor. The term malicious arrest is used in some cases instead of malicious prosecution, but the latter is broader in scope. 30 SRG and 1 foot. Wall SOIL Brothers TRRLLLSP Company, 200.
All right, all right. So now you guys should have a better understanding of what they can and cannot do. All right, that concludes the first section that we're going to cover. The next one is going to be arrest without a warrant. So that link should pop up somewhere in there. If it doesn't, then you're just going to YouTube search arrest without a warrant, James C. Lovett. And that will pop up next. So we'll be back in 2 and 2. Appreciate you guys. Go grab some goodies, some snacks, healthy. And we'll be right back in one moment.